Swayam Prabha. Digital India. Educated India.
Well, students, this is Dr. Ajay Kumar Singh, Assistant Professor, Faculty of Law, BHU, and this is my 30th lecture, which I am going to present before you. The title of this paper is Labor Welfare, Problems and Human Rights. So, in this lecture, we will try to understand that what are the problems which workers are facing in this country? What are the labor problems which laborers are facing in this country? So I have pointed you you can see on your screen, I have pointed out certain problems which I have put on your screen. Labor problem in India. The first problem is job security. Many times laborers, they feel insecure. Job security is very unemployment, bonded labor. So these are the some labor problems. Low wages, workers are not paid adequately. So, many times you might have seen that bonded labor problems are also prevailing in few parts of this country. So, low wages, poor service condition. This is another important area, poor service condition. Either they have to work in a very bad condition, or even many factories or industries, they do not have sufficient adequate hygiene, and workers have to face problem. So these are certain job security and employment, bonded labor, low wages, poor service, labor problems. These are the labor problems. On the other hand, I have highlighted that right to equality. You can see this again, Article 1 UDHR 1948, because we cannot start any topic pertaining to human right without mentioning Article 1 of UDHR, without mentioning Article 3 of UDHR. Lecture would be incomplete if Article 1 and Article 3 of UDHR is not referred. So whenever we have to start our lecture, particularly human rights, lecture on human rights, so we will have to refer the first declaration, the first international instrument, that is Universal Declaration of Human Rights, UDHR 1948, and we have to refer Article 1 and Article 3 of UDHR. Without referring these two important provisions, our discussions would be incomplete. So that is why I have covered these two important rights in each and every slide, in each and every topic, so that I can explain you that how right to equality is important, how right to life as a human right is important, not only for the human being, common man, but these rights are also important for workers or laborers who have to work in an industry or factory. They are entitled, workers, laborers are entitled to live with human dignity as a common man, as a being citizen of this country. That is why Article 3 is very important. So I have referred Article 3 in my slide, Article 1 in my slide. Now let us understand that what is the role of Parliament in removal of labor problems. So I have referred three important legislation. The first important legislation is Child Labor Prohibition Act 2016, Bonded Labor System Abolition Act 1946, and the Equal Remuneration Act 1976. So let us understand that House Parliament has played significant role in a removal of labor problem in India. As I said, due to illiteracy, due to poverty, due to job security, people have to work in any adverse situation. Either they are poor or they are illiterate, ignorant about their rights. They do not have sufficient means to survive. That is why few employers, they take disadvantage of their poverty. They take advantage of their poverty. They take advantage of their illiteracy. Few employers, they take advantage of the plight of laborers and they exploit. Media reports, judicial pronouncement make it more clear, and my argument pertaining to this labor problem become more important when Supreme Court, when we see the judicial pronouncement of Supreme Court and media report and government report on labor problems. Statistics data reveals that poverty and illiteracy are two major factors for child labor, for bonded labor, and these two important component, poverty and illiteracy, are important factors for labor problems. That is why laborers have to join the hands of greedy employer and they have to work under compulsion. They have to work under adverse situation. So for that purpose, Parliament has enacted three important legislation so that laborers cannot be exploited by the employer. The first legislation which I have referred, that is the Child Labor Prohibition Act 2016. When we use this word labor, worker, laborer, it means this word labor or laborer is very wider term. It includes child labor, it includes bonded labor, as well as common laborers, common workers. So if child labor related problems comes into the knowledge of enforcement agency or court, if bonded labor problems are reported, then judiciary will come forward and victim, aggrieved, they can come before the court and they can file a case against that employer who has engaged them in their industry or factory. Children are considered as asset of a nation, and in order to provide better facilities, better education, so that they cannot be exploited, our constitution makers, they were very much aware about the rights of children in this country. So for that purpose, our constitution makers has incorporated a special provision under Article 24 of the Indian Constitution. Article 24 of the Indian Constitution says that no child below the age of 14 years shall be employed in any hazardous industry or establishment. So, employment of child is prohibited by Article 24 of the Indian Constitution. No child shall be employed by any employer. That is prohibited. Article 15 clause 3 says that nothing in this article shall prevent the state from making any special provision for children and women. In accordance with that provision, Parliament has enacted a special provision for women and children, particularly in order to provide better facilities, better education, and in order to prevent child labor, Parliament has enacted Child Labor Prohibition Act 2016. The purpose of this act is to prohibit child labor, and it is the mandate of Article 24 of the Indian Constitution. Bonded Labor System Abolition Act was enacted in 1976 because of Article 23. It is the mandate of Article 23 of the Indian Constitution that no person shall be compelled to do any work against his will or against her will. So that is prohibited by Article 23 of the Indian Constitution. So in the light of that constitutional provision, Parliament enacted this Bonded Labor System Abolition Act 1976 so that bonded labor cannot be promoted, this practice should be discouraged, and no employer shall continue this evil practice. And if any complaint is found against any employer pertaining to bonded labor, he shall be prosecuted for this kind of practice. So this Bonded Labor System Abolition Act 1976 was enacted by Parliament in the light of Article 23 of the Indian Constitution. The third important legislation which has played significant role in removal of labor problem, that is the Equal Remuneration Act 1976. How this statute is helpful in removal of labor problems, you can understand that if this act talks about equal pay for equal work, then if any worker, any labor who is not paid equally, it would be violation of that statutory provision, and that labor, that worker has right to come before the court for the enforcement of that right. Now, I would like to refer to other important statute on this point, that is the Minimum Wages Act, Minimum Wages Act 1948. How this act, the Minimum Wages Act 1948, I have just mentioned this act. This act is missing on this slide. So the Minimum Wages Act 1948, how this act has removed labor problems in India are helpful. I am not saying that this act has removed all the problems related to labor, but this act has played significant role in removal of labor problems in India. This act has mitigated, this act has reduced labor problem in India. How? You see, this act makes an obligation, imposes an obligation upon employer to provide minimum wages to the workers working in their factory or industry. So by enacting this legislation, Parliament has imposed obligation upon each and every employer to ensure that every labor must be provided minimum wages working in that factory or industry. So this act would be helpful in removing the plight, in removing the difficulty of labor problem in this country. This is another important statute which we can see. Now come to role of Supreme Court in protection of rights of workers. How Supreme Court has been effective in protection of rights of workers, labor problems and begar. I have referred to important case laws, Dubbar vs. Union of India and T. Rangarajan vs. State of Tamil Nadu, AIR 2003. In Dubbar vs. Union of India, what Supreme Court said? Supreme Court said that wherever a person is compelled to do any work against his will, without remuneration, it would be considered as a forced labor. It would be considered, that act would be considered as a begar, which is prohibited by Article 23 of the Indian Constitution. That person would be held responsible for that. So this is the case where Supreme Court has clearly said that no person should be compelled to do his work, to do any work against his will or desire without remuneration. Otherwise, his rights, fundamental rights would be violated, and in case of violation of fundamental right, that victim is entitled to get compensation from the employer, as well as act would be also covered in that Bonded Labor Abolition Act. Liability would be imposed. Second important case on this point is T.K. Rangarajan versus State of Tamil Nadu. What happened in this case? About 1 lakh employees, they went on strike, and when they went on strike for several days, they were not cooperating the government. So government decided that no work, no pay. So government applied that policy, that no work, no pay, and on that basis government decided to terminate them from their services. Government said that since they didn't do any work during that strike, during that period, so they should not be paid. On the other hand, it was pleaded on behalf of employees before Honorable Supreme Court that strike is a means, a method through which employees, they put their demand to the government. Strike is a process through which employees, they raise their voice against the government if government is not doing well against the employees. But Supreme Court did not accept all these contentions, all these plea. Supreme Court rejected all these plea and held that it is a case of violation of rules, and Supreme Court held that strike is not fundamental right. Neither it comes within purview of Article 19(1)(b), nor it will come within purview of Article 19(1)(c). Neither strike can be justified under Article 19(1)(b), nor it can be justified under Article 19(1)(c). So strike is illegal, Bandh is illegal, and employees involved in strike or Bandh is unconstitutional. They don't have right to go on strike. This is not their fundamental right. So Supreme Court said employees who were on strike have no right to claim any benefit. Strike is not fundamental right. So this is Supreme Court observed Supreme Court made a very specific remark which I would like to refer in this case. Supreme Court said, a strike is a disagreement between employer and his employee. It does not mean that employees will go on strike. So this, though employees have right to organize assembly, they have freedom to make assembly peacefully, they have freedom to form association under Article 19(1)(c). They have liberty to form union, association. They can participate in agitation or demonstration peacefully. That is their fundamental right. But strike, they cannot hamper economic activities of state. So Supreme Court made observation in this case that when employees go on strike, they create problem for the state, they create law and order problem for the state, and they not only create law and order for the state, but they also they hamper all the legal activities, economic activities of the state. So during strike or during ban, state legal activities, state economic activities becomes paralyzed, and state has to suffer economic loss. And Supreme Court has also held that if any organization or trade union will go on strike illegally or will call for band in a statewide and will try to paralyze, will try to hamper economic activities of that state, the economic loss suffered by that district or by that state may also be compensated from the salary allowances of those employees who were on strike. Similarly, where political parties are involved in calling strike or band, Supreme Court has also given direction for political parties not to organize any band or such kind of activities. Otherwise, political parties can also be directed to compensate, to provide compensation to the, I think it's a good step where political parties, they go on strike, that statewide they organize band state-wise and they hamper economic activities of that state. So Supreme Court has said that they will have to compensate. They can be compelled, they can be directed, political party can be directed to provide compensation for the loss caused by the political party, loss suffered by the state. State would be at liberty to get compensation from loss suffered by the state from that political party which has hampered economic activities. So all these things, all these developments which you can refer, though that these things are not directly connected with rights of worker, but I just for reference, I referred these cases that even political parties are not allowed to call band or strike. So this is another important case, T. Rangarajan versus State of Tamil Nadu. Now come to another important aspect, that is Badua Mukti Morcha versus Union of India. You can see Badua Mukti Morcha versus Union of India. A PIL was filed by an organization, in this case Badua Mukti Morcha, that is an NGO, filed a petition in Supreme Court, and a survey report was submitted in Supreme Court. A survey was conducted by this NGO. Survey was conducted in this district, Faridabad district, Haryana. So, and that survey report revealed that there were bonded laborers who were involved in stone quarries factories, and they were compelled to do work against their will. Supreme Court found allegations true and ordered for rehabilitation. Rehabilitation is one important aspect to compensate the loss suffered by bonded labor or child labor. So it is the duty of that employer to compensate, to provide financial assistance to those workers to whom employer had engaged them in any factory or any industry, hazardous industry. So this liability must be imposed, and Supreme Court has already imposed this liability upon employers to provide financial assistance to the workers to whom they have confined in their establishment, in their hazardous industries establishment. So this is a very leading case, Badhua Mukti Morcha versus Union of India. This NGO is being run by Swami Agnivesh. This NGO has played significant role in abolition of child labor as well as bonded labor. Whenever child labor related issues, bonded labor related issues are highlighted, one important agency comes into the picture, that is Badhua Mukti Morcha. And second personality who has played significant role in abolition of child labor, has one personality who has played significant role in protection of environment pollution, that is MC Mehta. MC Mehta has played important role, significant role in prevention of child labor as well as in protection of environment. So one name comes into the mind of every citizen of this country whenever pollution, air pollution is brought into the notice of common man. When child labor issue is discussed in academia, then one personality, one name comes in the mind of the citizen of this country, and that is MC Mehta versus Union of India. He took responsibility to abolish child labor from this country, and I think I have no hesitation to say that MC Mehta has been successful in abolishing child labor as well as in protecting environment of this country. Apart from these two, Badhua Mukti Morcha, and now let us understand this case, People's Union for Democratic Rights versus Union of India. People's Union for Democratic Rights versus Union of India. This is a leading case, and this case is popularly known as Asiad case, where petitioner People Union for Democratic Right, that is an NGO, as name itself suggests, PUDR, People's Union for Democratic Right. Petitioner wrote a letter to Justice P.N. Bhagwati, and that letter served as PIL, was treated as public interest litigation. Allegation was that violation of Article 21, violation of Equal Remuneration Act 1976, Women workers were not paid properly. This was also one important issue which petitioner had raised in that letter. Supreme Court, you see what Supreme Court says. Supreme Court held that there was a gross violation of labor laws in this instant case. So what happened in this case? You might be aware about this Asiad case. During Asian Games, Delhi was conducting that game, and many men and women, including children, were engaged in Asian Games for constructing temporary cottage, temporary toilets, pathway roads. So labor workers, many male and female workers were engaged by the contractor. After the completion of the game, when workers, they demanded their wages, remuneration from the contractor, he refused to pay, and he said that he didn't get funds from the government, so that is why he was unable to pay remuneration. And you see, it is said that justice delayed is justice denied. Workers, male and female, they could not get their wages, remuneration, even minimum wages, fair wages were not paid in this case. So since they were poor, they did not have any idea about public interest litigation. So when this NGO, People's Union for Democratic Rights, inquired them, asked them whether what problems they were facing at that time. So on the basis of their perception, on the basis of their statement of workers, male and female workers, this PUDR decided to fight case on behalf of workers, laborers. Accordingly, petition was accepted as a letter petition, and Supreme Court found all the allegations true, and Supreme Court held that there was a gross violation of labor laws in this case, and government concerned was directed to provide fair wages, all the dues to the workers who were engaged during Asian Games. So you can understand the plight of workers who are engaged in such kind of activities, even government activities, and that act was, you see, that program, that Asian Game was organized by Delhi government. So Delhi government was directed by the Supreme Court that government should immediately provide all the remuneration, all the dues, remunerations to the workers who were engaged in that game. So this is all about your PUDR case. So you can understand that workers, laborers, due to ignorance of law, due to poverty, they are unable to fight their cases before competent authority. So it was that NGO, PUDR, which fought their cases, which decided to fight their cases on behalf of this, and in this way justice was done by Supreme Court in this case. Now with this, I would like to highlight another important case. You can see on your screen that is Randhir Singh versus Union of India, AIR 1982 Supreme Court. Randhir Singh versus Union of India, AIR 1982 Supreme Court. In this case, what happened? This case is important because in this case, Supreme Court for the first time held that right to equal pay for equal work is a fundamental right. The main question before Supreme Court was whether equal pay for equal work is fundamental right. Is it fundamental right? Article 14 was in question. So Supreme Court said that right to equal pay for equal work is not a fundamental right, but it will come within this. It is a DPS, Directive Principle of State Policy. And now government should achieve this objective, equal pay for equal work. Now, how to improve workers' problem? Though being a law student, I must suggest that by strengthening our legal framework, we can improve the plight of workers, we can improve the condition of workers in India. It is the law through which we can provide more liberty to the workers. It is the law through which we can provide justice to the workers. It is the law through which we can make them better in all the respect. But in spite of legal framework, we will have to make some extra effort additionally so that we can improve the condition of workers in this country. I have some suggestion regarding improvement of workers. I just want to throw some light on those suggestions, how to improve workers' problem in India. I have just chosen some important areas so that I can explain you that how we can improve workers' problem. The first thing is we can improve their skill. So by improving their skill, you might have seen that there is a huge gap between skilled and unskilled workers. As a result of that, in unorganized sectors, agriculture sectors, unskilled workers are working, and due to their unskilled behavior, due to their since they are unskilled, not skilled about their work, so that is why employer take advantage of their condition. So without improving their skill, this workers' problem cannot be improved. Second is training and awareness program. Government, state government, particularly state government as well as central government, each and every government as well as private establishment must organize training and awareness program from time to time. Particularly government agency must come forward to organize, to create awareness among workers so that they cannot be exploited by their employers. Training awareness program must be conducted periodically. Offering education at low cost, free of cost. And now this suggestion has been incorporated, right to free education, right to primary education, that is a fundamental right. But this right to primary education is not a fundamental right for those person who can afford, who are rich. This right to primary education is a fundamental right for those poor people who cannot afford education fee. So all the children above 6 and below 14 years shall have right to get free primary education in government schools. Government schools are uh, obliged to provide free education up to the age of 14 years. The third important suggestion is enhancement of salary and bonus. This enhancement of salary and bonus will improve the confidence level of the workers, and they will give their 100% to the organization where they are working. So periodically, year to year, every employer, whether it is government employer or private employer, must enhance the salary and bonus of their worker. Recognition, reward of employees. So this is another way to boost up their confidence by giving reward, incentive, additional monetary benefit, additional financial assistance, reward or bonus incentives to the workers who are performing well in any organization or factories. So it would be definitely helpful in achieving goal of that organization where workers are working. Now come to this other safeguards and issues. So I have chosen these 4 important safeguards. The first is health and safety standard, that is insurance policies. Insurance scheme, all the workers must be brought in under one umbrella, and that is very effective umbrella, and that the name of that umbrella is insurance policy. So it is the responsibility of the government ensure that every worker working in any private or government establishment must be insured by a company. So insurance, where life of worker is insured by insurance company, then obviously in case of any mishappening or in case of death of that worker, family members will not suffer. So for that purpose, health and safety standard is necessary. Second is minimum wages, as I have already highlighted that Minimum Wages Act 1948 was enacted. So it is up to the enforcement agency which must ensure minimum wages. This is third is labor enforcement agency. Labor enforcement agencies must come forward to provide effective safeguards to the workers. Workers who are working in any factory, industry or government establishment, it is the responsibility of labor enforcement agency. I just want to give the name of that labor enforcement agency so that you can have idea. The labor enforcement agency is known as labor enforcement officer in every district. So this labor enforcement officer is under obligation to ensure that neither child labor problem, that labor enforcement agency will have to ensure that not a single child has been engaged in any establishment, nor any labor as a bonded labor has been engaged, confined in any establishment or factory. So it is the responsibility of enforcement agency to ensure that there should not be any child labor problem in any district, nor bonded labor problem in any district. This is another important outdated technology. So many times it is seen that factories and industries, they do not renovate their old machines, 100 years old machines. They have engaged workers in that factory industry where they have not renovated their old machines. So the technology must be updated. Without updating technology, I think neither the production of that company may be increased, nor the employees, workers working in that factory may be boosted up, maybe. So responsibility lies in enforcement agencies. So they should come forward to, and the most important thing is ADR for speedy justice. Alternative I have used, you can see on this screen, alternative dispute resolution mechanism for speedy justice. How this ADR mechanism is necessary? ADR, alternative dispute resolution technique, can be helpful in deciding dispute expeditiously. Let us understand this ADR method in resolution of industrial disputes. Can you imagine that lockout problem, strike problem between employer and employee in any private factory or industry will not take time. So even on a very petty issues, workers, they go on strike. If they haven't get bonus on the occasion of Deepavali, or if they haven't get bonus on a specific occasion, so they don't consider that company or factory was facing financial loss. If any company or factory is facing financial loss and that company is not in position to give extra money, bonus, incentive to the workers on a particular occasion, though that company has been giving incentive and bonus, has given bonus and incentive on several occasions, but in a particular year when a company or factory has not provided bonus to its workers due to financial loss, due to financial constraint, many times it is seen that workers, they do not consider the actual position, actual condition of the employer, and they go on strike. If they will go on strike in such a situation, can you imagine that the production of that company or factory will obviously be affected? When production will be affected, then employer will have to close his establishment, enterprises, under compulsion, because he will be bound to close, he will be bound to close his business. So it would be very difficult situation for both the parties. It would be very difficult for employer and employee both, worker and employer both. So then if matter will come in the civil court, then it will take time to decide that dispute. So that is why if mediation is conducted, if both the parties sit together, employer and workers, they sit together to decide to resolve the disputes. So with the help of mediation, with the help of alternative dispute resolution, they can sit together and they can decide that now employer is agreed on certain points and workers are also agreed on certain points. Now they have decided, workers have decided to continue their work in that. So mediation, arbitration, conciliation, these are certain methods through which disputes between employer and workers are resolved. So I think if mediation is allowed, conciliation is allowed, arbitration is allowed in industrial dispute, in factory disputes, then justice would be speedy, and speedy justice is the mandate of the Constitution, right to speedy justice. Not only justice would be speedy, but justice would also be inexpensive. You might have seen that civil court, ordinary court take too much time in resolving the dispute. So if civil courts are allowed to decide lockout problem, retrenchment problem, strike problem, then they will take time to decide the dispute, and they will not only take time to decide the dispute, but justice would be more expensive for the poor workers. So to my knowledge, to my understanding, these are the safeguards where employer and employee can sit together and they should decide their disputes with the help of arbitration, with the help of conciliation, mediation. They can resolve their disputes. So these are certain safeguards through which employer-employee relationship can be strengthened. And apart from these suggestions, I would like to suggest that without having good laws and without having effective enforcement machinery, we won't be able to implement labor laws in real sense. So in order to implement labor laws in effective manner, we need to have effective administrative agencies, we need to have effective enforcement agencies, so that enforcement agencies can implement welfare schemes, can implement statutory provisions in effective way. For example, if labor enforcement officer is not working properly, can you imagine that this right to health, right to education, this right to work, right to these rights should be meaningless. So Parliament can make a good laws, but if laws are not implemented, enforcement agencies, if they do not take it seriously, then it would be very difficult for the legislature to achieve the objective. So legislature, by enacting law, achieve its objective with the help of effective administrative agencies, with the help of administrative officers. So I must suggest that law is always good, but due to lack of political will or due to lack of administrative competence, many times legislature good acts may also be defeated, may also the good statutes become ineffective because of incompetent administrative agencies. So without having good laws and without strengthening, without giving more liberty to administrative officers and without effective enforcement mechanism, we cannot implement labor laws in real sense. So I think I have highlighted each and every aspect of labor related problems in India, and particularly poverty, education, unemployment, bonded labor, child labor. These are some important sensitive issues which India is facing, and we have sufficient legislations, we have adequate legislations, but the problem is with implementation. Once administrative agencies, enforcement agencies have started in implementing these legislations, we must say, I must believe that I do believe that all the labor legislation would be helpful or would be very effective for the betterment of laborers, for the betterment of workers in this country. So I think I have highlighted the role of Supreme Court and how Supreme Court has played significant role in this in order to improve workers' problem in India by referring case laws, PUDR case, SCR case, Badua Mukti Morcha case, and T. Rangarajan vs. State of Tamil Nadu case, various statutory provisions. So I think you all have understood the things which I have just discussed in this lecture, and assuming that if you have remember all these things, I do believe that you can get success in your coming examinations. These are the very relevant things which I have just discussed. So with this, I would like to conclude this lecture. Thank you. Thank you all.
Understanding oneself, understanding others, understanding society at large, understanding the nature, these are all driven by basic human curiosity. We would all love to understand why things happen, what happens, what is the final outcome, why certain things fail. These are all exercises that we perform in various domains of knowledge. Therefore, knowledge in various domains, you would realize they are actually social artifacts. They have to be rooted into historical perspective, they have to be culturally salient, and there would be socio-political reasons behind this. Whether you talk with respect to engineering sciences, whether you talk with respect to physical sciences, biological sciences, social sciences, that is the reason why humanities and social sciences should be understood by all of us. The knowledge that is segregated, that is divided with respect to areas, specializations, all of them needs to be understood in its context. And what provides the context? It is the social reality. How do you correlate knowledge in a given domain with the cultural reality, with the social reality, with the socio-political compulsions? Okay, how do you understand the law of nature, okay, in its totality? And for doing that, you require the understanding of humanities and social sciences. Say for instance, if you are trying to understand the effect of a particular bacteria, a virus, any microbe, how it affects behavior, how it affects the organism, human being, you start looking at it from a pure biological point of view. If you are trying to look at a particular type of a wavelength, say for example, you are emphasizing on the understanding of the effect of radiation on human life, you are looking at things from a physical point of view. You are looking at the corresponding changes inside the body, you are looking at the physiological side of the understanding of the information. You are trying to understand why, despite knowing the risk that is inbuilt in the process, why still human beings engage into it. You are looking at it from a pure behavioral point of view. Why society at large admire things which has full of risk. You are trying to understand things from a pure sociological point of view. Why people use particular set of words to explain those experiences. You are trying to understand things from the linguistic point of view. So, there are a whole lot of things, and then finally you try to combine all of them to say that what are the guiding principles in life. Then you say you are looking at life, you are looking at humanity from a pure philosophical point of view. And this is what social sciences courses provide you. They provide the context to you in which you would be finally positioning the understanding of the knowledge in any given domain. It could be engineering, it could be sciences, it could be medical sciences, it could be social sciences stuff, it could be humanities stuff. So, contextualizing the knowledge is what humanities social science courses help you obtain.